You hear police in Canada say, well, he wasn't driving, but he was in care and control. Care and control. Sometimes it's pronounced these days care and control, but care and control. Care and control is a legal presumption that we have in Canada. If you're seated in the driver's seat of a vehicle, you are assumed to be in care and control of that motor vehicle. And if you're committing an offense, for example, of having a prohibited blood alcohol concentration within the 3 hours after that, or you're impaired in your ability to drive and you are seated in the driver's seat of a vehicle, that may be enough to establish that you were in care and control, and that may be an offense in itself, essentially. But really, it's a legal presumption that we've got, okay? It allows the court to come to an assumption that you posed a risk to society. The one thing that we don't want is people to start driving. Like, who cares if you're sitting in a driver's seat and you're drunk? Well, the concern is if you're in the driver's seat and drunk, you might put the car in motion and harm somebody, and really they're trying to stop a harm from happening. And they're also trying to deal with the fact that not always do the police come upon people who have been driving or have an intention to drive, but it is a rebuttable presumption. So there are circumstances where the obligation may switch to the defense, essentially, to prove something in law. Now, why do we have that? Because there may be reasonable doubt as to whether or not you had posed a risk. There may be a reasonable doubt just on the face of the evidence that's there that a person who was in the driver's seat was putting the rest of the world at risk by being in the driver's seat in that condition. And so it is a presumption that the prosecution gets in those circumstances when a person is in the driver's seat of a vehicle, that presumably they have care and control of that motor vehicle, and therefore if they are impaired in their ability to drive, or they have a prohibited blood alcohol concentration within 3 hours of that time, that is an offense, okay, and basically making out the impaired driving offense. But it's a rebuttable presumption. So there may be circumstances where you're in the driver's seat, you're in a snowbank, it's freezing outside, your car won't move for whatever reason, and you need to be in the driver's seat for the sake of preserving your life. And this does happen, particularly at this time of the year. And so you don't get in the driver's seat for the sake of putting the vehicle in motion. There is no intention of ever putting it in motion. And so despite the fact that you are seated in the driver's seat, there may be a circumstance where essentially you don't have care and control, and you can rebut the presumption. You can rebut the presumption by putting evidence in. Now, this seems to be contrary to the onus on the Crown to prove the case and your right to silence. And it is, really, because in those circumstances, the onus switches to you, that you have to prove your innocence in those cases. So very often police will throw this term around when they're dealing with somebody, and they won't really think about the implication of it. The implication really is that it's a procedural evidentiary shortcut that is available to the prosecution in Canada, proving that you were essentially a risk. But it is a procedural evidentiary shortcut for which there may be circumstances where you can rebut that presumption. But the funniest thing is, in the last decade, I've heard it so often said as care and control instead of care and control. And of course, you think of the development of the idea of the Karen, and I feel so sorry for every wonderful woman in the world named Karen who has had to suffer this. But it's quite funny because I hear it from police officers and people in the public these days. It's become not care and control, it's care and control. And nobody wants to be controlled by a Karen.